Hunley has the whole monopoly. I don't know who that son of a bitch thinks he is.
Welcome to Laid Back Law with your favorite lawyers from around the interwebs.
No. Piers Morgan is doing the hide my boner lean. That's what he's doing. Look at him.
I think this is actually the first time that a billionaire cut safety standards, and it was the billionaire themselves that died.
And that's what made Polieres. I don't even know how to pronounce this guy's name.
Polieres.
I'm board certified criminal trial law in Florida. I'm your man. Of course, you have to compensate me.
Discussing the most pressing of topics every Friday at noon Eastern Time.
I did this way before him. I had the big brain panel before Eric Hunley even existed.
All right. And we're
I love
live.
that shout out from Rakeda.
Yeah, I happened to catch that when I believe that was around Rittenhouse time frame when they were on together, and maybe a couple beverages were tipped back during their conversation. Just a possibility, but I always love that. I had that way before he even thought of anything. So, folks,
I just realized I wasn't watching. I didn't watch the new intro. I heard it, and I was like, "Oh, that sounds different than the typical intro." Now I got to rewind and watch it. Okay.
God, but for those who don't realize it, remember to subscribe. This is Laid Back Law. Totally went through a rebranding. I talked about this last week. If you like legal panels such as this with illustrious people and Viva Fry occasionally, this is the show for you. We do it every week. We catch up on law, laughs, whatever we can. And this week, joining us again for the second time is Nick Staroff. And I hopefully said that right.
You say it way better than I say it.
Okay, I think he's still working on his internet connection.
It's that crappy Swedish internet that they have over there.
Yeah, I think
it's
good
called capitalism internet like we have here.
I knew the accent for a second. I was thinking German, but now it's Eurovision, and it's Will Ferrell and the woman from
there you go.
The land with the little people. What are they called? The trolls?
The Lupus? No.
Trolls. They have trolls.
This is our first time meeting also, so I hope I'm not already being offensive.
His sound is fixed now, folks. Anyway. Okay, I got to find my way to X so I can pull something up. Nick and I were talking over this week about a subject that concerns me, and this is the was it Rex Heuermann, I believe is his name, the Gigolo Beach murderer guy, accused, by the way, charged. There is a propensity now with DNA, and it starts to worry me. Supposedly, they caught him partially by pulling DNA from his daughter's discarded cup. Now, this has been going on a little bit too. The Golden State Killer was supposedly found because of a relative's DNA who had put their DNA into a public database, and they said, okay, the killer is likely, I don't know if it's a first cousin or second cousin, but they were able to move around. My problem with this, and I think that the cup issue may be more extreme, and I thought it would be important to bring up, the daughter didn't commit any crime, as far as I know. Right. She's just wandering around, living her life, discarding a cup, and having people following her to pull DNA. It starts to get questionable to me in terms of what are her rights? Should she be stalked? Because that could be seen as almost a stalking for them to go extract that evidence. Where do these things go too far? And of course, I feel like they always do this when you have a particularly heinous person being charged, because they say, oh, Eric, that means you support a serial killer. Oh, Eric, you support somebody who is a predator. And I feel like they always go for these, edge cases to shovel things into law. But Nick, am I describing this well enough?
You have, they found, well, as you said, they extracted from the daughter and they extracted from the wife, and after the fact extracted from Rex Hoyerman, and that was cups and stuff, trash and stuff, just to get to evidence they claim was found on the victims. And the evidence they found on the victims was hair. And so far, up until, well, the now recent charge against the fourth victim, they only had mitochondrial DNA, which is
Female.
Yeah, it's from the female, and they only had mitochondrial DNA regarding 3 of the victims, as far as I know.
Well, there's a whole issue with. I mean, there's in my mind, there's a bunch of separate issues. One is the reliability of a child's DNA to identify a suspect, which I think is a fundamental issue with the science.
Yeah.
But especially if you only have half of the DNA, assuming.
No.
Well, it sounds like maybe they've got the mothers as well.
Yeah.
But the other issue is can the police follow this girl and grab her discarded monster cans or cups or whatever it is? And the Supreme Court of the United States has ruled essentially, yes, if you throw trash at a curb, it's available to the public. They can grab it without a warrant.
But that's trash. I get the disposal, but the following part I have an issue with, because now you're essentially stalking somebody.
Well, that is stalking her. Not to justify it, but that would be the least objectionable things. They're following to, find someone relevant. She might be able to give some information. And I pulled up a link as MLS is talking, where it's from Harvard University. So now I don't know if I can believe it anymore, but it says, it talks about how the courts have always held that you throw stuff out in public, you have no reasonable expectation to your biological
Fair enough.
But following her, big deal. I mean, they probably have court authorized permission to do it in the first place. It's not stalking; it's legal at that point. But
assuming they do, assuming they have a warrant to follow her, the always like if you think back to the mafia days when they were trying to bust the mafia, and they would follow the underlings to try to get at the bosses. Generally, you didn't need a warrant when you were following them in person if you had eye contact. And then they started using like recording devices that could listen through walls, and they started using GPS trackers and things like that. And the courts have been firm that if you're not going to be within your eye following them as if you're walking down the street, then you need a warrant for that. But if they're legitimately just like boots on the ground walking behind her, I don't think that there would be any warrant requirement, nor do I think it would be illegal. There's actually some case law, at least in Michigan, that I looked at with regard to private investigators and stalking charges. And so private investigators following people around, you don't have a warrant for that. It's completely legal. But the court said once they realize that you've been following them around, even if you are a PI, at that point, then it becomes stalking. So under that sort of analysis, if she never knew it, it's not stalking.
Which, if you think about it, I think it makes sense. I don't have the same problem that you seem to have with this, Eric, because like police are supposed to do investigations. We want them to be able to find.
Are they investigating her though? Like I have no problem all day long when you follow him and he discards a cup and then they get it. That's great. But she didn't do anything.
No,
that is my issue with it. Is like, again, I've seen that 100 times. Totally agree. If they follow him, they suspect him, whatever it is, and he throws away a cup, cool. But this is a person who did not do anything, and that kind of starts to get into a gray area to me.
Okay,
I think the gray. I'm sorry.
Go ahead. No, you go ahead. You go ahead. David.
I was just gonna say the gray area to me starts when they then get the DNA sample and they run a DNA profile on this completely innocent person. That's where the gray area starts to me. And do you need a warrant for that? That's where the gray area starts for me. I don't know, Joe. Where you
okay, so that go. I like that distinction. I don't have a problem. And I think it makes if you sort of let's think this through for a second. Each part of this, okay. So on the one hand, you have the following element. And, we're protected from search and seizure, not from being tailed. The reason why I think that once you're made, as David, things change is because at that point you're feeling harassed. And that that feels violative when you're feeling harassed. But if you don't know that you're being watched and they're not they're not peeking in on you by using, you know, high-tech devices, but they're basically waiting for you to do something in the public sphere that gives them an opportunity to further their investigation. I don't know, it doesn't,
Again, of the suspect, though, not a relative. Okay, this is our distinction. Follow him all day. I have no problem, none with that whatsoever.
Let me ask you this, Eric. Me as a member of the media,
Mhm.
I want to follow around some general person that might be ancillarily connected to some sort of crime or something like that. There's nothing that prevents me. There's nothing unlawful for me from just driving and following them. Now, if I'm made and they say, hey, stop following me, then it could border on that harassment and stalking thing. But if I'm just driving around literally taking pictures of the same person all day long, there's nothing illegal about that.
Depending on where you are, if you're in public, if you know,
well, yeah,
it's
in
like
public,
that.
yeah.
No, I mean, you have to qualify. It's like, do you follow them
Yeah,
to
no,
work? What's going on there? Do you go into the building? And again, what is your purpose? You know, that actually starts to get weird too. Even as a media member, why are you following? Why aren't you talking to them? Why don't you approach them? Why aren't you asking a question?
They're in public.
And in this case, when it came to Rex Hoyman, they started following him around for a good year and a half before they actually apprehended him. And while doing that, they collected samples of his family members' DNA, because they did not have. They first collected from something that Rex discarded.
Yeah.
And there was, so far as I know, only a mitochondrial towards one of the victims, Megan Waterman, not the rest.
Well, what I was going to ask
So
you,
then,
Nick,
it was
is how
then
did
they started to go for the others. Okay, it doesn't fit him. Does it fit any of his other family members? Is that jump too high? Because they were never suspects.
How did they get the mother's DNA or the ex of the serial killer? I forget his name. Did she volunteer that, or did they get the same way? I just feel like the whole development of the DNA profile, that's the icky part for me. That's the part where I have a problem with. But I don't know the law necessarily about that.
Am I the only one? Am I the only one who never even thought of the fact that stalking requires the knowledge of the person and not just following them? Where if I'm just looking at the criminal definitions, and it causes the victim to fear for their safety, yada yada. Never even thought of that. But consensus is following someone in public is not problematic, and picking up their biologics if they've disposed of them in public, not a problem. So
you have to have that knowledge.
I don't know, and this is the problem. You know, it gets really weird, and Dave and I are on the same line with the ickiness. We'll go back to Golden State. Remember, somebody submits their DNA for the record at 23andMe or whatever it is, and then their DNA gets turned over. Are you all okay with that?
No,
because that's what's going on.
That's a very different thing.
Yeah,
that's a very different
terrible
thing.
analogy. You should be ashamed of yourself, Eric.
It's not an analogy. It's
hang your head in shame, sir.
The reason that's a very different thing is because you're forming a contractual relationship, a relationship with 23andMe, where you are voluntarily giving up something for a specific purpose, and they are interceding into that relationship to further an investigation into you. To me, that's much grosser.
But it's my family, and I'm just saying, hey, my DNA is there, and I put my name on it, so my cousin can match up and say, hey, you're my cousin.
But I'm just saying, any of these things which you're dealing with some sort of private agency and trying to learn more about yourself, but then to use that as an opportunity for them to learn about you feels far more intrusive than you voluntarily discard a can of Monster drink and them picking it up and then following you, even them following you around. I don't have the same. You're making a big distinction because the person's not a suspect.
Correct.
I want to point out,
following him around.
Well,
Why not his disposal? Then you go. Here we go.
Suspect. I mean, so I'll throw that back. I'll throw that back in your face, Eric, in the following way. Think about this for a second. Why is that person a suspect? They have like some hunch or inkling or something like that. There's been no probable cause in that scenario. So why are you more okay with the suspect, and it's not a violation of that person's civil liberties, than if the person's a relative of the suspect or an associate of the suspect?
Go ahead and follow that all the way through, dude, because you answered your own question. I mean,
Well, no, because that
no,
what do you
person
mean?
very well could be connected to the crime. That
there's a
person could
reason
have
they get turned up
conspired
as a suspect. There's a reason they get turned up as a suspect. They're somehow connected. They were at the scene, or there's something else, and they're not going to be investigated. So that breaks down in logic. I'm sorry, but they don't just go, "Oh, look, you're 6'2" and blonde." So there, no, there's a reason that I was there at the store at that time, or I'm known to drive back and forth to the store, and somebody resembling me was there. There's a reason that I'm a suspect. So
yeah, but suspect is such a loose term.
That's my
police
point.
say,
It's a loose
listen, we think that she might have helped after the fact conceal evidence of a crime. Boom, she's a suspect. I mean, it's such a loose term.
You have a reason.
Well,
but again, that's another step forward. Being related isn't. Being related is not a legitimate
I think where's Nate? He might be able to answer the question as to whether or not in the context of an investigation, you only get to follow suspects and not people who might be relevant to the investigation.
Where is Nate? We need Nate.
Nate has an appointment today, guys. He may jump in later. I don't know.
Well, hold on.
But that would actually be a good question for him as a former officer.
Yeah, but if we can go back to the DNA, because as I said, from up until just before this new arrest or this new charge, they only had the mitochondrial DNA. All of a sudden, they claim they got nuclear DNA results from 13-year-old hair samples. Not root hair, hair. That was from on Barnes, on a belt buckle. So, yeah, I mean, outside head area. And I've found a study from October 2022 from Department of Forensic Sciences from Washington University. And in that, they conclude prior studies that it is basically impossible to get nuclear DNA from hair because it's already degraded. But all of a sudden, they found nuclear DNA from all the samples from the victims. That I find really odd. And then when you look at the results, 7.9 trillion times more likely. That's not an unusual number. Here comes the weird part. 2.374 times 10 to the power of 48 is an insanely high number. That is a 1 with 48 zeros. Trillion, that's 9 zeros. I think 9. So that is, even in the press conference, the prosecutor said, it's such a high number, they don't have a name for it. It took me roughly 5 seconds to find the name for it.
Google?
Something of the zillion of the sort.
See, now I have an interview later on today with Tiffany Roy, who's a DNA expert out of Florida. And she's going to argue against you, Nick, and say that the numbers don't matter. That just because it's such an astronomical number, it doesn't mean that it's for this particular.
But here's the thing. Yeah, I know. But here's the thing: when you present numbers, they have, in my opinion, they have to be somewhat realistic compared to other trials. You have the Shabusiness trial, where they had the guy's actual body parts to compare with, and they were still in the trillions with actual body parts. And here they claim they could match it with hair in a number that is not 5 times higher or 10 times higher. It's to the power of 38 higher. And then the next number is 2.778 times 10 to the power of 480.
Did they use that to establish the probable cause to arrest him? I'm not sure the context.
No, the mitochondrial was to charge him for the 3 first. The 4th was thanks to this nuclear. And just for a comparison, just to how insane of a number to the power of 480 is. If you take the number of stars in the observed and unobserved universe, it's to the power of 100. And they claim they found a match to the power of 480. A power of 100 is a Google. That is one of the highest named numbers. And here they claim to the power of 480. And that from hair, not even hair root. from hair. And the method they are using is the SNP method.
You see, Nicholas, I want to point something out to most people, and I'm probably in the category of most people in this. When you talk about odds and you're saying that it seems unreasonable to jump from a number that is relatively small in like being 5 trillion versus a much larger number of like, you know, something followed by thousands of zeros, and a number followed by thousands of zeros. I think you lose a lot of the audience because a lot of people are like, you know what? I'll tell you. Let me just finish my point, and then you can respond. Because people are like, once I'm at even one in a million, it seems like it's hard for me to accept. 1 in a billion, 1 in 10 billion, more than the number of people on the planet. Once you start getting to the hundreds of billions, trillions, and now you're going to make a distinction between 1 in a trillion or 1 in 4,000 zeros behind it. It's these are numbers we can't comprehend, and already at 1 trillion. So it doesn't even make a difference at that point.
But it does make a difference because why lie, Joe? Why lie? Why exaggerate to this degree? Why not just say 1 in a trillion? Or just say over this? Why would you go to the ludicrous level? That brings questions. Like if your science is so bad that you can't even get within a spectrum here, I'm going to question your science. That's nuts.
And I think that is a really good question. Why these numbers? Well, most people only care about match, and then they don't care about the numbers. That is why I reacted so much to these particular numbers. I'll give you an example. Zachariah Anderson was convicted because of a match. They didn't tell the numbers. They found mitochondrial DNA in that speck, and he was convicted because in mitochondrial, results is they can exclude 99.69 of the population, which sounds clear and cut, yeah, but that number is 48 out of 10,000. Or 38 out of 10,000, something of the sort. It's 7 out of 2,500. In a small community of 2,500 people, you have 7 exact matches in 99.69.
What I'm understanding is that it's hard to develop a full profile from only mitochondria, the mother side of the DNA. That's the fundamental issue.
Yeah. Well, also the hair DNA has been shown to not be reliable at all. It's almost like a modern bite mark. Because remember, bite marks were all the rage for a while, and then they were like, yeah, that's kind of bullshit.
Well, I don't know. I would be more inclined to trust a bite mark than a speck of DNA. But
you said Bundy, I think.
Tell the chat what mitochondrial DNA is.
Yeah,
I sent a link in the private chat because I don't know what the hell it is. Mitochondrial DNA is the circular chromosome found inside the cellular organelle called mitochondria, located in the cryptoplasma. Mitochondria are... What the hell is it?
It's
Nick.
DNA that comes from the mother. I mean, to simplify it to a high degree, it is the female line of DNA, and it is the first discovered in forensic science, as far as I know. I'm not deep into it. But
half the profile. It's half
correct.
the profile.
Yes, it is the mother path to track it down. They I don't recall what the father's DNA is, but mitochondrial is kind of the first DNA that they've been using for a while. Almost, I guess it's kind of like the Jewish faith. It all comes from the mother.
Well, I mean, but then the patriarchal DNA will definitely trump the mitochondrial
of course.
DNA.
It's going to overshadow. Of course.
Much more important and much more reliable. Damn it.
I was going to say mitochondrial DNA is what makes you Jewish if you're Jewish, I guess.
Yeah.
So essentially, there's a lot of DNA issues with what's it, Giglio? Is that how you say that? The Giglio?
Gilgo. Or the Long Island serial killer, the Lisk
That sounds
murders.
better.
Gigolo.
Yeah. But that is one of the issues when it comes to DNA and DNA evidence. Once you say something else than it's a match, people stop listening. When they maybe start listening at that point, because DNA in itself is not a slam dunk. It has to be corroborated with something else. Why is that hair there?
Right. It has to be where it shouldn't be.
Yeah.
If there's no other reason if there's a reason DNAs could be there, then it's already problematic. Like
I think they call this the CSI effect. You know, like ever since the show CSI, everybody, pretty much anybody who watched that show, it kind of became part of common cultural vernacular. You know, like all of the different names for the different kinds of testing, and people trust DNA evidence much more substantially, and they rely on it more heavily than they probably should. But they, you know, like Nick said, if you hear that something is a match, you'll stop listening, and people don't really understand the science enough to interpret it. They just kind of believe what they're fed. So it has to be explained in a different way. It has to be challenged.
Yeah. And one of my other points here is one of the country's top scientists can't get nuclear DNA from here, but this Long Island's crime lab can. How is that possible?
Well, they're very advanced, obviously. They have some technology that nobody else is using, I guess.
I guess.
I don't know.
No, there just seems to be a lot of issues with it. But the issue I think Eric raised at the beginning with following someone who's not a suspect and grabbing their discarded whatever on the, you know, in a public area, there's nothing illegal about that.
True.
But going back to, I want to kind of explore this a little more. Is it lawful for the police to develop a DNA profile from your discarded garbage without a warrant, regardless of whether you're a suspect or not? I feel like the courts, if they've ever analyzed this, is going to say yes, because you basically discarded your DNA profile by throwing it, you know, something away.
But I hate this because using that theory, you know what? I'll just go walk around and collect everybody's discards and just start building profiles on everybody on the planet. It seems a little.
Well, Joe's already doing it.
Well, you hack into Ancestry's databank or 23andMe. You know, people will voluntarily spit in a tube and send it into, you know, some kind of.
They volunteered. They volunteered for a purpose.
You just described Tuesday for me, so.
All right. Well, this has nothing to do with DNA, but I'm going to use it as a segue anyway, because a Trump prosecutor is probably sharing DNA. I believe
with who?
With another lawyer on the team,
Nathan Wade.
It appears. But this judge. I know Joe should have some thoughts, and I believe David.
Oh, you got to play the video? I love that video.
This is the judge on the case discussing how her claim, you know, this is not a political prosecution. So this is the judge's thoughts on it.
Using the title of your office and having on social media that you, as this political office holder, are holding a fundraiser for the opponent of someone that this political office is investigating. I don't know that it's an actual conflict, but I use that phrase, what were you thinking? Where the prosecutor thought I could prosecute the co-defendant of someone I defended. It's a what are you thinking moment. The optics are horrific. If you are trying to have the public believe that this is a nonpartisan, driven by the facts.
Bullshit.
And I'm not here to critique decisions. The decision was made, but if we are trying to maintain confidence that this investigation is pursuing facts in a nonpartisan sense, the matter of the district attorney is we follow the evidence where it goes and ignore the fact that I hosted a fundraiser for the political opponent of someone I just named the target.
I love that face. I love that face. That face is great.
Actual conflict level, but if we are at a cocktail party and people are asking, do you think that this is a fair and balanced approach to things? I do. Well, how do you explain this? How does one explain? I mean, that's the concern I'm working through, is that it's not a lowercase a appearance. It's like a capital A with flashy lights, fundraiser, district attorney for the political opponent of someone I've named the target of my investigation. I'm the legal advisor to the grand jury, and I'm on national media almost nightly talking about this investigation. It's problematic.
Okay.
Hunley, can you send me that link?
Oh, sure.
By the way, that guy was not being sincere in his objectivity. That he doesn't. I don't think it's really bad. That was overt insulting her intelligence and her ethics.
Capital A with flashing lights appearance.
I'm not saying you look like a crooked scumbag, but you look like a crooked scumbag.
I love how he worded it so precisely, though. I mean,
it was beautiful.
I can't. I mean, yes, it was very well put.
That judge was elected and not appointed to the Georgia Fifth Circuit Court for Atlanta, Georgia, May 24th, 2022. So that's not an
Good
elected
job,
position.
electorate. That's a great judge because he's calling it like he sees it. I like him a lot.
I do too. So what do you guys think about this? Because it's so interesting. Have you noticed this pattern of lawyers, Michael Avenatti, who like to go after Trump and then they wind up getting jammed up themselves because of whatever the hell they're doing? It's I think it's an interesting pattern. And the Fannie Willis thing, I mean, her bit looks like a disaster.
Yeah, Fannie Willis sought extra money from Fulton County to relieve the county from the backlog after the CVID thingy. She used that money to prosecute Trump and to hire her alleged boyfriend. And
who's not qualified. No, her boyfriend, from what I understand, has never prosecuted a case like this. I don't know what his resume is.
Never prosecuted, never defended. He has zero experience in RICO trials.
And he's the lead.
Yeah.
And people don't realize this, but there actually was a hearing this week which exposed his complete lack of experience in RICO, in that the defense brought a claim that the charges had to be dismissed because in order for there to be a valid RICO charge, the state has to establish that there is pecuniary gain. Now, with respect to Trump purportedly trying to wrongly take the election, the state could have made the charge that that his motivation was not to stay in office, but for the financial benefits of being president. If they had an experienced RICO litigator, one would think that that person would have thrown that into the indictment charges, and that way you just tick off that box. But this guy, when you're not experienced in aerial law, you don't realize that there are certain boxes you need to tick off. Now, the defense of the government of their indictment charges is like, well, we don't have to bring that up in the indictment. That way, it's something we ultimately have to prove, but it's not something that's not something that we need to necessarily allege in the charge indictments. And they may manage to skate by on it, but right now they're fighting a fight that they would not need to fight if, in fact, Fannie Willis had hired someone competent rather than an utter incompetent boyfriend who was going to use the money to purportedly take her on cruise trips.
Yeah, wasn't he charging, if I recall, like 24 hours of labor?
There was one entry where he billed 24 hours in a day. Just so everybody knows, by the way, that clip that you shared is from last year, so that's not even on the most recent. That's not on the most recent Roman, what's his face, Michael Roman's motion to disqualify and strike the charges.
But he also. I'm sorry.
His bill is about the wazoo.
One other, when you talk about things that look shady, he billed twice for going to the White House. And it's part of his special prosecution, which sounds crazy that, the left is trying to say, oh, this has nothing to do with Biden, And he's meeting with Jack Smith. He's going to the White House. And it's not like you can say he's going to the White House for some sort of tour or some other thing. He's billing, like he's on the clock working as a special prosecutor when he's going and meeting in the White House. Now, was he meeting Biden specifically? I don't know.
Ooh, good point. So that shows a collaboration or could imply it.
Precisely.
He was
just going to the records department in the basement. That's all. He was just sifting.
Okay.
But you understand? Like it's so egregious. They bill for their corruption the same way Michael Sussman billed the Clinton campaign to meet with the FBI to give them the Steele dossier, and then he still got acquitted in a DC court. So the bottom line is, it's so brazen because there's no consequences. But the 24-hour billing, I mean, I'm sure his defense is going to be, I didn't break it down. It was over the span of a few days, like other charges. But it's crazy. Fannie Willis got up in front of that church last week and basically testified to how innocent she is and how she's a servant of God and how she
persecuted.
And
not racist.
Oh God, you've never heard more racist drivel in your life from her. But then she says, I didn't pay Nathan Wade any more than I paid the other two. And apparently the Daily Caller put out an article that said that she basically lied there because she paid another person $200 an hour, not $250 to her boyfriend.
Yeah.
That's okay.
And the guy who is the lowest paid of the three, he's the one with actual RICO experience, and he's paid the lowest of the three. I mean, you can't make this.
Was that guy an attorney? That one who was paid the lowest of the three? Because I saw that and I was like, that could be a bit of a false flag. There's always going to be a built-in markup for someone who's an attorney and someone who's like an investigator, and that's what I think. I think that was something that I sort of felt as if the right was a little bit over trumping, because we know that. Look, lawyers are thieves.
Over trumping.
Perhaps I didn't. Pardon the pun. I'm just trying to be fair in criticism, because when you try to over criticize in ways that I think are very easily defensible,
here you go, Joe.
Doesn't strengthen. He was an attorney. Oh, okay, fine. In that case, that.
No, but I get what you're saying. Yeah, don't try to overemphasize things that are highly defensible.
But if he was an attorney and a RICO expert, then yes, it's shameful.
Yeah. Although I had to say, $150 an hour for an attorney. I was charging that when
it's pretty cheap.
I first came out, and I had someone tell me, if you're only charging $150 an hour, that means you're not worth anything. Like
I got told the same thing. I increased my rate just based on that theory alone.
Yes,
and
me too.
I got more work. I got more work. Yeah.
Much more
Depends
work.
on the market. You're in New
It's
York.
Like, you're not a good attorney because you don't charge enough.
That's
the hourly rate of like a mid-rate therapist, basically, which is,
And here I am doing salaried.
It's the market. I'm telling you, though. A New York attorney and Atlanta attorney are two very different things.
But I'll tell you, we had our car thoroughly cleaned out because there was some mold in the carpet. Florida's very humid, and the car cleaner, the detailing, they charged $125 an hour for that. I mean, it's the world has gone crazy now.
Is Michigan that different from Atlanta? That David heard the same thing when he was charging $150 an hour. I think New York is different.
Well, I think Michigan's probably a higher rate area.
Well, I'm in Metro Detroit. It's not like I'm, in a rural area, so there is a difference there. But if you go to like the Metro Detroit area, like Detroit, downtown Detroit's 20 minutes from my office. We have higher rates here. But
it's always the balance. You can charge $300 an hour, but then you can't bill as many hours in a file. You can bill at $150 an hour, but if they see that you're billing more than they think you should, they'll think you're making up for it on one end or the other. So
that's true. Just to talk about.
We lost.
Just to talk about like politics of the office, I increased my rate, but I tend to bill less time for things. I try to aggregate them as much as possible because I don't want to burn through my clients' money.
Should I share with you a secret that I came up with for dealing with clients? Because I hate taking phone calls for like these stupid things. So I basically tell when I would sell myself, I jacked up my rate like much higher after I heard that, and I said every lawyer charges you in increments of 1/10 of an hour, and they round up. So as soon as you get that first minute on a phone call, you're charged for 6 minutes. And as soon as you go to 6 minutes and 2 seconds, you're charged for 2/10 of an hour. That's just the way that they charge. I mean, now they have incremental, like actually on the clock. I said, I won't charge you the first 6 minutes. I round down. If you call me and you manage to stay on the phone for if you're my client and you call me and you stay on the phone for less than 6 minutes, I will not charge you anything. And that helped me like basically not have to deal with clients because like them calling me all the time, because it's just like they just sort of felt like, okay, I'm not trying to rip them off, even though I'm charging them a much higher hourly. They sort of recognize that I'm not looking to nickel and dime them and grab every penny I can from them, sitting there with my hands rubbing together on every.
I would think they would be calling you more often with that.
Well, what I try to do is aggregate. Like if I'm sending a text message, an email, and doing a couple of phone calls, I'll throw all that together and do like 0.16 minutes. That's what I try to do as much as, but I type it all out, like email the client, follow-up text message, phone call later on in the afternoon, and just throw it in there as one. But anyways, sausage being made and all that good stuff.
Yeah. Okay. So let's go on.
Off topic. I'm sorry for that with the whole hourly rate thing.
I'm having flashbacks to doing billing and like for all of the attorneys in my last firm.
By the way, Patrick Bet David created an app literally for that express purpose of charging people by the minute, so they wouldn't have to pay more or less. I forgot the name of it, but
it's called Minect.
Yeah, Minect. Connect for it's connect and minute. So you connect, for whatever minutes you say. It'll be 4 minutes, and you pay 4 minutes or whatever it is. I don't know how effective it is. Of course, he said it's amazing. We'll see on that. Let's go and jump to another case this one kind of relates to, I think we were talking about this last week somewhat, and I got into an argument a little bit with Nate about it, about being able to bring up propensity evidence. Like in a serial killer case, if they have a kit, that can be brought in if they were, let's say, stalking and robbing houses and they had a kit with them or whatever, that could be used. And speak of the devil, and he shall appear.
There we go.
Hey.
All right.
Can we rewind our prior conversation and ask Nate the question we're all begging to ask him?
Okay, let's ask him. Nate, I don't like it when people walk around, follow people around and collect discards if they're not actually a suspect in a crime. And everybody here said it's just delightful. Do it more. What are your thoughts?
No. We said it's legal to follow somebody as long as you're not made. Then it's not like harassing or stalking. As long as you're not made, you don't need a warrant to follow people around.
That's how they got Koberger.
And potentially pick up discarded things and then use those to develop a DNA profile. That's what we're talking about.
That makes sense, because if you're trying to because don't forget, you both try to find suspects and eliminate people as suspects. So sometimes
is there a definition for suspect, and is there anything that's required, like internally, that you need to develop as a police officer to say this is a suspect, so we're going to go follow this person around, or anything like that?
Well, there's a lot of factors: opportunity, timing, all that type of stuff. So, and there are different levels to it. Like if you're in a group of people and we don't know who in that group is the guilty party or innocent party, we may, check everyone or slightly follow everyone and just see, if you drop something and then do a DNA profile, you'll never know. Sometimes I've even pulled LUDs, the phone records of people who had nothing to do with it, because we don't know at the time. And then when you find out that the person has nothing to do with it or is not.
What if you do know that this is not a suspect, that this is the daughter of somebody who's a suspect? That's where I'm having the issue. When you say excluding or including, you're saying it's possible. And technically, when you say including and excluding, that means they're all suspects and you're trying to take them on or off the list to move to the next step. But if it's somebody who's a relative of them, that's not technically.
And you're specifically doing it to develop a DNA profile against the suspect. That's the situation here. So they follow the daughter around to get her remnants so they can try to develop a DNA profile to connect the suspect to the crime. That's the specific scenario.
Well, just to be clear, it's 100% legal. Number one, just so now I understand people may have issues with that, but that's general law enforcement. They caught the I forgot the guy in San Francisco from the same
Golden State Killer.
Yeah, they caught a couple of people,
but his was in a database.
Yes,
that was relatives to
the
they had relatives, and I have issues with that too. People submitting their DNA for a database, not for the express purpose of, you can just go track all that down, and it's controversial.
There has been legislation to see if they can limit law enforcement, but as of right now, constitutionally, yes, they can follow around. Yes, they can do. Yes, even people who they believe are innocent, if they can maybe develop some facts to get to the guilty party, and as long as because don't forget, the Constitution stops illegal searches and seizures and those type of things based on probable cause, not intrusion. Because again, a lot of times if you're discarding something and stuff, it's fair game, unless like MLS said, they're not actively harassing you. If they're doing it on the slide where you don't even know that's happening, then you really have no recourse.
Yeah. I have no issue with Nate if it is a suspect that disposes of it. My issue is when you start following relatives and pulling their info. Yeah. It just feels, at a minimum, it feels icky.
Invasive, I would say, is the
and in this case, they are testing against hair. They tested the suspect against all the hairs found, but it wasn't a match. Then they started collecting from the wife, from the daughter, and from the son to see what if this hair is connected to them. And by then, they only had one suspect, and that was not the wife, son, or daughter. It was the man.
But just because you have one suspect doesn't mean there may not be, because I know I read some reports with some people that theorize that the wife may have been implicated in some things, which I'm not sure if she was or was not. But again, just because you do have one person doesn't mean you can't then, their orb of influence, who they all associate with, you can do a light investigation to see if the wife may have been involved, if some of her hairs may have been on the bites and so forth, so forth. So it does seem icky, but I don't. It's just not illegal, guys. And there's worse things that the police do. Like for instance, phone records.
Great, thank you, Nate.
No, because
that's so much better. Please share.
Phone records, for instance, we can't determine just the LUDs, like who you've called and that type of thing. They can pull that at essentially any time, and stuff that's even available just on online for regular people. You pay for someone's criminal background history. You go pay for it in a free service. Like a lot of this information is out there, anyone can get. So the way the court users look at it, if a regular person who's minding their business is not breaking the law, if they can get the information, then the police should be able to use that information.
I think it's innovative.
No, that's
personally.
a good question. I'm glad you brought that one up, Nate. You're talking about like the license plate scanners, that there's company that go around literally driving and just scanning license plates all over the place. And the police technically would have to get a warrant, but then they'll just go pay the service to find the information, just like a PI. Is that what you're talking about?
No, because that would actually also be illegal. If the police can't pay someone to search someone else, because then they're the agents of the state and they would still need a warrant. With what I'm talking about is if you throw something away into the street, any civilian can pick that up and use it the way they wish. It's discarded. But the Supreme Court has said if the police were to do that, they are not restricted from doing that. So if a regular person can legally take some property, like say in this case, she discards a napkin with her DNA on it and throws it in a trash can. And if a regular person can take that napkin and there's nothing illegal about it, then the police can also take that napkin and do what they will with it. That is the state of the law right now.
Right, and I don't disagree with that, again, as a suspect, but then
not for a suspect, anyone.
Can I walk around, take pictures of license plates? Is that illegal?
I don't believe unless there's some type of law that prevents you from doing it. Generally,
you don't have a right to privacy. You don't have a right to privacy, at least in Michigan, to your license plate number.
Yeah.
Right? Because it's out there on your vehicle. You don't have a right to privacy to that. Now, what you do with that information, if you're going to try to access like a government database and you're not authorized to do it, that's different. But no one has.
I just collect them. I put them on a database, and then people pay me because they want to find it.
No, I would say there's nothing
but then the police.
I don't think there's anything illegal with that. I know it's icky, but it's just the way the law is now.
This is why you get a cabin in the woods on 100 acres and you stay away from everyone.
I'm much more bothered by the phone records thing. That feels far more invasive. I drew this distinction of where you form an individual forms a contractual relationship with a corporation, and they necessarily have to give that corporation access. I'm much more bothered, excuse me, by the cops having an ability to just start culling that information together, because that makes it impossible for any individual to live unless he's going to live off in some forest somewhere in his own stupid little tent. But it makes it impossible for you to interact with society without divulging a great deal of your privacy that's really no one's business, including the state, without exposing yourself to having anyone and everyone, especially the state, know everything they want to about you. Like the phone records, that's a very invasive thing. Who you talk to on the phone, that and that's a very, very invasive type of thing. And the fact that a third-party company has that information because that's a necessary part of your relationship with them, that all of a sudden that exposes you to the state knowing it, to me seems kind of ridiculous. I understand it's a law. I'm not saying you're wrong. I'm just saying it seems very...
I do want to... We're talking about constitutional protections, right?
Yes.
Constitutional protections are very minimal. They take things out of the democratic process. Doesn't mean we can't pass a law and make some of these things illegal, but good luck with that.
But I do want to also mention, too, a lot of times you'll never even know they pulled your LUDs and these companies, which we used to hate, fight tooth and nail not to let your information out. So, for instance, like we'll hit a telephone company or even a cable provider or an internet service, and they generally have like 30 days or 60 days to respond to subpoena. They fight tooth and nail on your behalf. Now, I know you guys might say that's BS, but Apple is like the worst. So it's like AT&T. They will fight tooth and nail to not let you. So you do have some
there's a reason. Hold on, there's a
unfortunately-
reason for that. Because Apple makes bank on privacy. Now, Apple, technically, their customer is the person who buys their product. Google's customer, for example, when they sell Android, is not the person buying the product. It gets a little bit shadier with them because you are the product when you're using Google. So they're happy to get information out there and sell that information. Apple is guarding it because that is a competitive advantage. It's not because they really care necessarily about their customers. They're banking on that. You are buying their product and you have that relationship. That's something that they are selling.
That happened with the San Bernardino shooting, I think.
Yes, it did. Famously, the FBI tried to get Apple to do it. They couldn't get it done, so they went to Israel, who wound up cracking it. There's a company in Israel that can pretty much crack anything, from what I understand.
And this is going to freak everybody out, but there is a legal loophole. So, for instance, in this Giglio Beach murder case, if the police illegally got the information from the mother and daughter, they could still use it against the primary because he has no legal rights to challenge the illegal obtaining of the evidence against the wife. He would only if they obtained it against him. So let's say
it's so much worse.
It's crazy, right? I know. So if I violate,
because the crime is against her, not him.
Exactly. So if I violate her rights to get the evidence, she won't be able. I mean, he won't be able to challenge it in court because his rights weren't violated. It was her, so she can make a big. But
that's a torture question, almost, Nate. Because
I know it's crazy.
Technically, if we were getting deeper into that. Let's say a rubber hose is involved with somebody who then gave over the evidence. Yes, you abuse that person's right, but it's against somebody else. I mean, you could take that to a really dark place.
Yeah, you really can. And it's horrifying to think that you have less civil rights if you're not a suspect, if you're not their prime target, than if you are. That sounds to me so backward. And if you've done absolutely nothing wrong, literally like you were just saying, Eric, they can torture the mother of some suspect and whatever they get out of her that's beneficial to their case, they're able to use it, and it's not considered fruit of the poisonous tree. That sounds so stupid. That's such a
that's the icky part that I was getting at. Like, I don't have a problem with the police following people as long as they're not made and then picking up their trash, but then developing that DNA profile when they're not a suspect, there's not a warrant. That's the icky part. That's the part I don't like.
So it's not part of the poisonous tree because it comes from a different tree, which kind of it's an admissibility loophole. It makes it admissible. Is that?
Yes, because see the court, so the person, the target, his rights were never violated. It's someone else's rights. So it's a standing issue. You can't sue for someone else's rights being violated. You can only sue if your rights were violated.
So could she sue then if it was the mother?
So she. But the thing is, the state's not even prosecuting her. So it's like, all right, yeah. So we're not using it against her at all. We're using it against the husband, and then the husband wouldn't have any recourse because they'd be able to. It would be admissible against her.
Would she be able to successfully get so in Michigan, if you're charged with a felony and you've been bound over, you actually have to give your DNA sample. Now, if the case is dismissed or you're acquitted, that DNA sample needs to be destroyed as well as your fingerprints and everything else. But so would she have the right to sue to have her DNA profile destroyed? And if it's destroyed, then it couldn't be used against the suspect.
Well, I would suspect that they would have to probably argue that out in litigation, like especially if you're talking about state law specific and all that type of stuff. Yeah. But right now, let's say, for instance, if let's say my friend I gave my friend a gun, and that gun and the police violate his rights and grab the gun and find that it was my gun that I used in the robbery, that gun's coming in. Because they'll say, we didn't violate your rights at all. We violated your friend's rights. And he may sue 1983 claim. He may give us some money, but I'm screwed. And you obviously, you guys are lawyers. You guys know this for a fact. So it's one of those weird little quandaries in the law. But yes, the innocent person, if they violate their rights to get evidence against the criminal, that still can be used.
And they, by the way, it's kind of creepy if you consider, because they can lie, cheat, do whatever they want. And most of the time, the innocent person, if they don't take it to the torture level, which I just said, obviously, that they could just get nailed for that. But lying to them or conning them or scamming them, it's pretty hard to prosecute.
Police can do that. DAs can't. And that's the fine line there. And when police do it, the DA has to turn it over to the police, and then the defense attorney gets to ask the cop.
By the way, that's American law. I found out I had Alder Ray on, who is a criminologist, behavior expert, out of England by way of Netherlands, and in England, I believe, and Netherlands, and I maybe Nick, you could speak to Europe. Police cannot lie to a suspect. That is a very American thing.
That has there has been up to the EU court certain cases where it's against the European Chapter on Human Rights for the cops to lie to a suspect. So it's established on the highest level in Europe, in the EU and in Britain.
Okay, and I just wanted to express that because we do have an international audience, and I think that that is actually a worthy discussion of whether this should be allowed or not, because we have different cultures, different courts who are saying it. I don't mind the misleading aspect of it, but the pure lying aspect of it is pretty, I don't know. I'm going to go icky again. Like if you say, what if I told you somebody said they saw you at the store at 10 o'clock? That's not technically a lie. It's an implication, and it's really hedging the truth, and I'm being deceptive, but I'm not lying.
They do that with gangs all the time. Like for instance, you'll get one of the gang members in. You'll be like, all right, so your boys, they said you did it, blah, 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 blah. Said you are the shooter. And then that person then says, no, it's really blah, blah. So that's generally the general lie that police tell, because they're trying to induce a confession. But again, there's a fine line for that, because then if you do too much lying, then is this a confession or is this coercive, and so forth and so forth. So that's what the courts deal with every day.
Right, but what you just described was a direct lie, not an implication.
Yeah, and I have to say, in EU, Europe, Britain, cops still lie. So just because it's been established at the highest court does not mean they quit lying. I mean,
I'm sure they just do it on the sly, and where it's not recorded. I mean, obviously, cops. I'm sure that cops, Nate, you could speak to it or not you, of course, but you might have known others who don't always color within the lines.
Well, hold on a second. Didn't that boozy guy confirm that Nate had unlawfully locked up people? Have we all forgotten about this?
Nate hasn't. It's still in court.
First of all, just whatever, not to bring back bad memories, whatever happened with Boozy and the scandal?
Still in court.
We're still waiting. So now where's it at now? So right now there was another motion to dismiss. So the original judge threw out the defamation, really on a technicality that the statements that he was saying was true. So if they're true, they're not defamation. But in New York, a lot of people don't realize this. In New York, you can still sue for true statements if they imply defamatory things. So it's called defamation by implication. But that's what. So we said, okay, so it's defamation by implication, because if you're saying the statements are true, Nate, the lawyer, is not a lawyer. Well, Nate, the lawyer is a lawyer, and you're implying. So we refiled it that. So now we have a new judge, and that judge is trying to figure out if this is defamation by implication. But obviously, he said he knew my real name. He said I wasn't a lawyer, and he implied it. So it's on our side, we think we're good. But again, with these judges, you just don't know.
And has Boozy's social media presence taken a hit since then, or has he been?
Yeah, he's been draining for a while. But mostly because of his spoutable shenanigans and
because he's blocked 4 billion people on Twitter.
Oh, he's blocked me. I have no idea what he's up to. He blocked me like a while ago when we were doing fundraising for your original legal fees, Nate. I wonder if he's still sitting in his kitchen on that little stool waiting. I'm curious to see what happens with this next development.
Yeah, well, we're definitely still waiting. I think something's going to happen soon. You said, Nate.
Yeah, we're hoping. Everything is there, so the judge, has to. But the judge dismissed defamation, so we raised defamation by implication, and they're arguing that the judge dismissed the defamation by implication claim. But the wild part of it's in the ruling. The judge literally says plaintiff didn't raise defamation by implication, so I can't speak to it. But they're saying by the judge saying that means the judge dismissed defamation by implication with prejudice, which is not the case. It's like,
but defamation by implication, is that different than false light?
It's the same as false light, but false light is what's known as a common law tort. Defamation by implication is a statutory tort in New York. So, for instance, my false light claim was dismissed in New York because New York doesn't have false light. They have defamation by implication. So it's similar, but it has different criteria and everything. Now, for those of you who are in the chat, just so you understand, the difference between defamation by implication and defamation is defamation, the statements have to be false, and the defamation by implication, the statements have to be true. So you can have a true statement that the seminal case is there was a guy who was working at a job, and they put there was a whole bunch of massive thefts going on at the job. So they put a sign up. If anybody has any information on someone stealing from this company, let us know. And they put his picture right under that sign. So that was true that people were stealing, but they implied that it was him. So that's defamation by implication.
Oh, that's interesting. And not like the brothers, the Osundara brothers, saying that they're gay is true, but defamation or defamatory because it could get them in trouble in certain jurisdictions.
Well, no. They actually saying someone is. Well, the courts have unanimously said saying someone is gay is not defamatory. Not anymore. Maybe back in the day it used to be. But the Osundara brothers, even if they were, they would have to show it that had some type of defamatory implication.
Question about that: when you say that saying somebody is or isn't something isn't necessarily defamation, could that be circumstantial? And what I mean is, like, if making a false statement about somebody will cause them to lose their job, their career, whatever it is, because of, I don't know how to explain it, where they work, while the statement, I'm going to use the gay example, maybe they teach somewhere something ultra religious or whatever, but it's not acceptable and they're a religious figure or something, and they lose their livelihood, etc. Couldn't that technically be defamatory or a problem?
Well, yes,
I'm not wording it well. But
that's a pretty gay question there, Nate.
there's the case that's on point with this is the accountant case. So a guy was an accountant had an issue with some guy. The guy said, "Hey, you don't know anything about these general accepted accounting principles," and this. So he wrote like this big post, and the guy lost a whole bunch of things. But if someone says that about you or me, hey, that's true. But about an accountant, that's specific to the account. So the court found that could be defamatory. So there are specifics that you. There's a
distinction between defamation per se and defamation per quad, which is where you're really finding this question, Eric. Defamation per se is what I believe Nate was saying. That's certain statements are considered inherently derogatory. So if you make a statement about someone that they're a thief, that is considered inherently derogatory. And it used to be, presumably, that if you said someone was gay, assuming these statements are not true, that would be something that's inherently derogatory. So you wouldn't need to prove that element. So that's considered defamation per se, and the level of damages are also greater when it's defamation per se, as opposed to defamation per quad, where someone says Nate is not a lawyer. So a lot of people are not lawyers. That's usually not considered defamatory. If anything, it's usually considered praiseworthy to not be a lawyer. But considering the context. Considering the context of what he is and who he's doing and what he's presenting to the public, so you can understand how that is derogatory for him, and that's considered defamation per quad, where you need to establish part of the elements you need to establish in your defamation claim would be why that's harmful, derogatory to you in this specific context. So the case of the gay thing, where you were talking about someone's a teacher in a school, theoretically, even though it might not be defamation per se, it could theoretically be defamation per quad if it's something that's impactful on you. That's my take on it, but I'll defer.
What about sarcasm? And I'm not trying to be ridiculous, but Nate's
well, sarcasm is inherently a joke, and a joke is not defamation generally, because you're not trying to state a fact. You're making a joke.
I also think parody gets you off the hook. I'm pretty sure that John Oliver did a whole segment on something like that. He did.
But literally doesn't mean literally anymore.
Well,
could that be a defense though? Could you just say, "Hey, I was sarcasm"? Like if somebody said, blah, 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 and I go, "Oh, sarcastic."
But again, all of these are because like even with Johnny Depp, a lot of people don't realize Johnny Depp's case was actually defamation by implication. The statements that she was saying were true, but he was saying that like the fact that she became a spokesperson for battered women or whatever
for SA.
That was true, but the implication was that he did that stuff to her. So, it's a famous case where it's defamation by implication.
Right, because he wasn't named, but there was the implication in the article because she talked about being married 2 years ago. Who else was she married to? It's common public knowledge that she was married to Johnny Depp, even though he wasn't named in the article, and even though she didn't describe the incidents that occurred, it was in the headline and in the title, and so it was implied. So,
and that's very similar to that. That's very similar then to the Boozy thing, because he said blah, 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 blah. And then when it pushed back, he said, "Of course I knew this."
Yes.
Read between the lines. I knew, or whatever it was.
Yeah.
So he essentially said, I knowingly did it. Now, Nate, if he said, I was being sarcastic, get over it, then you wouldn't have a case, right?
No, I would still have a case because, again, it's not about him saying it after the fact. It's at that particular time, were the people who were involved in the conversation, would they have known, would a reasonable person would have known that he was being sarcastic at that particular time? And obviously at that time, he wasn't being sarcastic.
So
well, at least
I'm completely lost. I took my headphones out for a minute. Who are we talking about?
Christopher.
Oh, the Boozy case.
Nate, I had a
Boozy.
question
Okay,
about.
all right.
Do you mind if I interject? I was curious. I had a question about that because I remember that one of the claims, I don't know if this ended up going into the suit, but I remember that he had watched one of your YouTube videos. He heard you tell a story about you apprehending a suspect, right? And he had,
sorry, Emily's here.
He had generously misinterpreted what you said and had accused you of engaging in some kind of criminal framing of a suspect. Now, is it malice if he comes with a defense that, you know, he misunderstood your wording and he felt that you had been speaking in earnest? I'm curious if that ended up in the suit and if he had a defense to that particular aspect.
Yeah, so we actually dropped that from the suit because we thought well, hey, you know what, because again, sometimes when you're doing these things, you want to get the things that are obvious versus things that are kind of like seem to be maybe nitpicky. One person can interpret it this way, that way. So we said, okay, we have some things that are extremely obvious here. He said this is obviously not true. He said he knew it wasn't true. That's one. Here's another thing he said, like for instance, he said the thing about the receipts. He said that I was stealing money from this. He then put the receipts showing that I wasn't stealing the money. Then that's obvious, right? So it's like, all right, just let's hit with the things that we know we have. And then things that have a battle, we'll just leave those out. So that's what we decided to do. So that was like, okay, anybody can interpret it with any way, so it doesn't matter.
Can stupidity be a defense to malice?
That's a good question. I didn't know any better.
If it's genuinely stupid, then it wouldn't be malicious. It would just be ignorant or moronic.
Like if somebody doesn't have professional expertise, but they make an assumption that somebody's doing something illegal. They make a claim that that person's doing something illegal because they're not a professional in that area. And they make this claim in earnest because they reasonably believe the statement to be true. But it
depends on how they phrase it in that way. Because I could see somebody saying, this person's guilty of SA, when in reality, it's not actually a crime due to some technicality, probably statutory sort of SA.
I think Nate covered that, though, because he said, do a retraction. And instead Boozy doubled down. No, in like Nate's case, like let's say that it was ignorance that was there. By asking for a retraction and then the person refuses to, then that would probably take the ignorance defense out of it. Help me out.
Well, for actual malice, you have to show that the person knew what they were saying was false. That's the one thing that Thomas hates about actual malice. And there are like three ways you can do it: circumstantial evidence. And in newspapers, they usually say, was there any evidence to show that what the person was saying should have been, should have considered that this could be false? But for instance, in the Boozy case, for instance, Boozy said, I knew his real name and I said it anyway, quote unquote, read between the lines. So that's a clear thing that he knew the information he was saying was false. And with that, literally, I was telling people to read between the lines and pointed back to where he knew the information was false.
The law tends to be far more favorable to plaintiffs who are claiming defamation per se than when it's defamation per quad. Because when it's something that's so blatant that it's offensive to anyone, the law is going to be far more favorable to the plaintiff. And with respect to Chandler's question as to whether or not stupidity of the defendant would be a defense to take away malice, I think the distinction might be whether the statement that was made is defamatory per se versus per quad. So it might be an effective defense in a per quad case, whereas it wouldn't be in a per se case. By way of example, okay, so if someone is really stupid and they think anyone who takes money from a bank is a thief, so they walk around and they say, oh, I saw that guy come out of the bank with money, he must be a thief, and he basically goes around saying that guy is a thief. So and the person who's saying it is Forrest Gump level stupid. So now that still would be defamation because it's something that is an offensive categorization for anyone, and we're going to be protective of the plaintiff, as opposed to if Chris Boozy is genuinely that stupid of a human being that he doesn't realize how
jury's out.
Yeah. So in theory, he could say, "I'm really look. Face it. Look at my entire Twitter timeline. You can see I'm really incredibly stupid, and that's why I can't be held liable for my misunderstandings about what I understood about Nate."
But
What would be worse,
but-
arguing
but-
that you're really dumb or that you intentionally defame somebody?
True, but by the way, Joe, to continue on that though, if then Nate says what you said is wrong, you need to retract that. So you're now educating him, and he says it again. Doesn't that take that out?
Yeah, that could
Yeah,
be.
that
Yeah.
does.
And that's one of the reasons I sent a letter like that.
I got to jump off real quick. Bye, guys. I just want to
Thanks,
say bye to
Dave.
everybody.
Good having you.
Later.
Take care, all.
Has everyone been watching the January 6th pipe bomb video scandal?
Which one?
Which
The latest video. Well, the latest video showing the apparent placement of and discovery of the January 6th or the January 5th pipe bomb.
I did
No,
see
I don't.
news that the pipe
Hold
bombs
on.
resembled the ones that are used in FBI training exercises.
Yes, that was Jack Posobiec. Jack Posobiec put that out here.
Yeah.
I'm going to give this to Eric in the backdrop. Darren J. Beatty. I think the revolver has been busting this one open. There's a 6-minute video surveillance of the alleged. I think it includes the planting of the pipe bomb, but certainly includes the discovery of the pipe bomb. Darren Beatty walks through why it makes no sense. Like the cop cars were allegedly informed that there's a pipe bomb next to this bench where they happen to be, and they don't do anything for a full minute. And if you go through the thread, you're going to see there's a. I'm going to talk about this at 2:00, not to sell my own show out early, but the resemblances between the FBI training pipe bombs and the pipe bomb discovered are striking. And Posobiec pointed it out. What's his name? Sebastian Gorka, for whatever the reason. I thought he was being sarcastic, but he wasn't. Defended and said, no similarity. How many caps? How many different types of caps are there for pipe bombs anyhow? So it's fascinating. Everyone should, if you all you know, I'll share that link in the chat, so everyone can go watch that. But I'm gonna break it down at 2:00. But no, man, I tell you, it's amazing. They found everybody. You know, they found a grandma in Arkansas, and they found another grandma in Alaska. Can't find the cocaine in the White House. Don't know whose that was, and they don't know who planted this pipe bomb. But if you see, I think it's So
we got a timestamp because I don't know what's going on.
Yeah,
go down to the replies to that tweet because he breaks it down and gives you the highlights in that section.
Oh,
This
okay.
is- yeah. So that's not my Twitter feed. Ooh, I got nervous for a second. So then we see here, yeah. So the footage shows the discovery of the pipe bomb. The first clip shows approximately 1:05. A man in a backpack approaches a Metro PD. And it tells him it's a pipe bomb, and they don't do anything for a minute. All right, it's beautiful. Everybody's got to go see it. But
did they did radio or anything?
No. Apparently they just sit in their car for. Well, good question. I mean, are they in their car radioing in for help?
Because two things. Number one, if I know the training they used to give us, and now it's got to because all these things are coming back. So the devices that they show you are actual devices. Sometimes they'll recover whatever. So if they'll bring a device and say, "Hey, it's a device," and now if somebody makes a similar device, it's like, yeah, but they show us actual devices. But the second thing is that generally you're not supposed to radio if you're near the device because
because you can set it off.
Yeah, so there's a device down there. You're supposed to stay put, radio it in, and then have the people who go there actually who deal with bombs. So I've made that stupid mistake where I'm like sitting right over the device, like, hey, yeah, we got the device here. Blah, blah, blah. They're like, are you next to the device? I'm like, yeah. Like, you're not supposed, like you should hang up and call us.
No, I didn't even think about that. But yeah, a radio signal could potentially trigger a device depending on how it is set up. I never thought of that. Let me see, Justin, right
but
there.
But again, chat, don't kill me. I don't know if this is legit or not. I'm just telling you the training that we got. So.
Okay, well, Justin, right. Let me see. There are arguments that the timer is a standard kitchen 2-hour timer. Why was it planted the day before? Okay, I don't know. I mean,
yeah, that's one of the things Darren Beatty brings up in the revolver. I went through this a long time ago, and
did they even confirm it was not not a real pipe bomb? I mean, do we know that?
I don't know. Did it explode? Was it inert?
No, it did not explode.
No, but was it even real, or was it just Republicans released?
Those of you who are confused about the whole pipe bomb, you need to understand contextually. You might forget what happened 3 years ago. So a large number of police force were diverted from the Capitol and protecting it right before there was the breach on the Capitol because there were reports of a reported pipe bomb, I think both by the DNC and by the RNC. So they got split off by the headquarters of each of those campaigns respectively. So the police were essentially cleared out of the Capitol, making it much easier for the Capitol to be breached. And the suspicion that many people who are conspiracy theorists, meaning that they're way ahead of the curve, they're way ahead of the curve, that is that they were specifically diverted in order to enable that breach and set up the ability for the siege to happen, and thereby create a bludgeoning force for the DNC, for the Democratic Party to come after MAGA specifically.
Mm. Well, Nate did a lot of reporting on this, that everything that happened was written about the day before, essentially, in all the papers, that there was going to be a huge influx, riots. You did a video on that, did you not, Nate?
Yes, and I'm called the conspiracy theorist. Joe called me out, but yes, I am the conspiracy theorist. So what we did, and people saw the video. Remember, they got permits, and they were like, we didn't know anything. They got not only did they get permits, they literally wrote exactly what they were going to do. We're going to storm the Capitol at this time, and we're going to go here and go here. So everything was out in the open, and the Capitol Police and the law enforcement in the Capitol were on record being asked. They said, "Hey, listen, this is what the MAGA people are saying. They're going to come through the tunnels. They're going to do this. They're going to do this." They literally listed it all out, and they said, "Well, we don't, they're MAGA fantasies, and we are not worried about them at all." Then next thing you know, then later on during the hearings, they're like, "We didn't know anything." So I'm like, "But you obviously did, because you literally said you didn't care about it." So a lot of the key point here is that the whole January 6th was not an insurrection. I get a lot of heat for saying that, but it was not an insurrection. It was a riot that turned bad. And one of the biggest issues is that they knew these people were coming. They knew this riot was going to happen. And when you only have 5 cops to stop 10,000 people, it's less likely that this wasn't, that there was some really incompetent leadership. And that's why the head of the Capitol Police, the head of the sergeant at arms of both the Senate and the House resigned, because it was the highest level of incompetence that you could have, knowing you're going to have tens of thousands of people coming and only have 5 cops there to stop them.
It sounds completely inorganic.
This is an interesting question here. FBI agent who handled the GOV, the Whitmer case, also was transferred to that bomb squad. That's very interesting.
You see, so here's the thing on that. I mean, it's and I understand that the association there is very sounds immediately very sus. I understand why that would make the hairs on the back of your neck prickle. I get it. But it's like, do you think that we all think that the FBI is really corrupt? Would they really need to use the same person? That's what makes it seem like, I'm like, I don't know.
Whoa, Joe, in that case, I'm
asking that question. I mean, tell me an answer.
Yes. Do you realize how few people are trained at EOD level to handle explosives? It is a very specialized field.
Oh, you're saying most of us are expert, demolitions expert.
Yeah.
Oh, okay. That would make
that's a very specific tight-knit job. So no, you might have to.
Okay, so if you're telling me that the guy has certain specialties that were necessary in both capers, so in that case, I can understand why they would need to use the same person. That answers the question. I was asking in good faith. Like I was like,
No, in a bomb squad case or whatever, because like in the military, we have EOD. Okay. It's a very specialized deal, because most of us are smart enough to say, you know what, I could find something safer to do with my life.
Right. But does anybody find it interesting that the FBI had so many informants there? They don't even know how many were there.
Of course,
they were
it's like, go check your payroll, assholes.
There was so many. They were like, we don't know how many we had there, but we had a lot. It's like
interesting is a generous word, Nate. Yes, interesting. I do find it interesting.
It is interesting.
I had on Tarek Johnson, Capitol Police Officer, and he was talking about the infamous memo that was circulating. Yogananda Pittman, I forget what her position was, but she was basically like police chief, Capitol Police chief, whatever. December, they had an internal memo detailing exactly what the threats were, what the risks were. They knew people were going to come, try to infiltrate, try to take over. They buried it, and then they half-staffed, and then they didn't call in National Guard, and then they framed everybody who was there.
It was in all the papers, literally in all the papers, how this was going to happen, exactly how it was going to happen. None of this was a surprise, but it was a surprise to the security apparatus, it seems.
Oh, and then we coined the term insurrection and used Goebbels techniques to repeat it for 3 years to get people taken off ballots. A very specific person taken off a ballot. I mean,
now, by the way, can I whet the appetite of the general audience for my upcoming show at 2:00 about the Canadian wildfires? I'm going.
Is that simultaneous spark that they showed on the video a while back?
Hold on. Let me just. I'll put this. I'll give you this tweet, Eric. So this is the tease. Okay, will this work? Hold on. If I share the. I'm so stupid. I just shared it here. I'll share it here.
Yeah.
Go and look at this. The fact checkers. The fact checkers. Read what they said at the time, and they're going to say, "Well, we didn't have this information at the time." Bullshit, because I can bring back my tweets from the time. Freaking fact checkers said no evidence that the Canadian forest wildfires, the forest fires, were the result of arson.
Go ahead, Nick. You were saying something?
Huh? Oh.
Yeah, you started to say something.
Oh, yeah, sorry. I need to jump off because you're all breaking up from me. I can barely hear you, so I need to figure out what's wrong with my computer and internet.
It's the fabulous Swedish internet. You guys have...
It's good to see you, Nick.
Good to see you, Nick.
See you all.
Socialized internet.
Yeah.
Join my drinking stream later tonight. I might have bad tequila today.
Ooh.
Oh.
Put some links out there so we can grab
Nick, I don't want to shock you, Nick. You got a cat on the top of your body.
I think it's the chair behind him.
Mr. Jingles.
And when I say bad tequila, I mean bad tequila. Jingles.
I thought
Nick is furniture. If you have a cat, you are furniture.
Yeah, I'm a cat tree for this asshole.
Oh, it is you. I thought it was a chair. He's totally on your shoulders, huh?
Yeah. There he is.
Oh, yeah.
Oh, now he's going to flex and show us his butthole.
Well, he has some legal opinions that he wants to
share. He's going to climb down and put his tail in my face.
That is a cute cat. Like, they're not all cute and they're not all beautiful.
That is a 12-pound barn cat. So, yeah. And now he's using... Oh, thank you.
Well, I'm glad you could join us. Tell him thank you for his opinions.
Okay. Okay, but thanks for having me on. And I'll see you all later on my stream. Okay.
All right, Nick.
Bye-bye.
Talk to you later. All right, so we've got David with his subtle tweets. It's funny because David is the nicest person on the planet, but on Twitter he's an animal.
Correct and retract, you fake fact-checking scumbag. No evidence wildfires in Canada were set intentionally. If your time is short, there have been no reports the wildfires in Canada were set. Bullshit. This was bullshit at the time. Canada's government said the wildfire. Oh, Canada's government. Go trust Herr Trudeau, you sons of bitches. Climate change is also causing wildfire. The vlog that's coming out today is going to break this down. This is the news from yesterday. Let me just pull up one of my...
Oh, actually, you know what? There was another case that just came out, David. I don't know if you saw earlier. 5 Times August tweeted it, that there was an actor who's 50 years old, and they suspected his death was related to COVID, and the autopsy has come back saying that self-inflicted gunshot wound was involved.
That's crazy.
Who was? I didn't hear about this.
So, I mean, that kind of makes me wonder. I still want to know if George Floyd was counted as a COVID death.
Maybe until they redid his certificate. What you read the report that just came out? Like 17,000 deaths were attributable to I don't know if I can say it. That medicine. Have you heard that? You read that study?
I haven't read the study. No,
Please be very detailed for us so that we on YouTube can understand it better.
No, we'll just say go visit Alex Berenson on Twitter or whatever else.
Was it perhaps a liquid and a syringe that people had to, perhaps get
Oh my God!
Hey, what's up, guys?
Oh man!
One Nick leaves, another Nick arrives.
Yeah, the Nick swap.
Oh my goodness! Be careful.
Well, he's got the cat behind him too. No, the study allegedly claims that there were upwards of 17,000 deaths caused by prescription. It's not the horse paste. Which one's the horse paste? No, it was the horse.
Ivermectin.
Dude, we're trying.
Oh my gosh!
Wait, can you not say
we were
that?
dancing
still?
around that
No,
word.
it's a joke.
I don't want
Eric
to
is staring daggers
and
at
you
you
just
right now.
walk
I don't care. I don't care.
Ivermectin
No
this,
one take it.
ivermectin that.
No one take that thing. It's terrible.
So no, my whole question was the study apparently is total bullshit. They're taking people who are hospitalized, were being administered excess, very high prescriptions. They were already on death's door to begin with. Set that aside. Up until they relabeled their deaths as potentially eye inflicted, what were they qualified as? I guarantee you the 17,000 deaths were qualified as COVID deaths. So now what they're going to go do is retroactively say, oh, well, let's see what we can play with here. And now that we've benefited from the 17,000 deaths from COVID, now let's see if we can blame it on something else for our new political narrative. It's unbelievable.
You know what? I wish I had the body count of COVID. Because you just can't do it with melee weapons. And I just don't have the time. But man, it was such an effective killer. And it's like, man, God, that's like conqueror levels of death right there. Like you go down in history books as the good guy with that one, like George Bush or whatever.
Population reduction. Very.
Oh, it was hydrochloroquine, according to the chat.
Was it HCQ?
Oh yeah, that one.
I forgot about that. I've seen Joe Rogan talk about that. I'm pretty sure he did.
Well, remember that there was that woman in Arizona that supposedly they took it and she just managed to take it.
She poisoned
her husband. There's no question about it. She killed him and she found a good way to get away with it. Yeah, it was HCQ. That was so not
Trump told me to take it.
Unbelievable.
So
Nate, I didn't see you there. You're in red face today. How's it going?
Yeah, I'm doing all right. Just making it happen.
And we're all canceled. That's it. Done.
Well, we'll find out soon. Good God, it doesn't take Nick long to burn it down.
Oh man, I'm going easy here. Come on, I say way worse on my own first.
You don't watch Nick's show.
No, I know Nick's show.
Yeah.
If I may also shameless self-promotion, Nate, I don't know if you saw the interview I did yesterday with Alpha Warrior. And this is a guy who got FBI raided over a tweet, literally. And he's former military, United States Marine Corps, served in Iraq, was law enforcement for 14 years. And when the FBI did their pre-dawn raid, they did, as he said, and there's video evidence, flashbangs before they called him up on his phone to say, we've got your house surrounded, will you come out? And he said in his experience, you do flashbangs as an absolute last resort if you're going to be prepared to do a forced entry. And my theory was that they did the flashbang so that he would get scared, think he was, a violent criminal was at the door, go to the front door with a gun so they could execute him the way they did that guy, the Utah guy, over his Facebook posts. Tell me I'm smart.
You're very special.
I don't know about all that.
I'm not
You're too smart for me to understand sometimes.
Well, actually, hold on. What about? I'm so surprised if Eric has talked about it.
Not yet. The reverse Floyd.
Yeah, it's crazy.
Okay, yeah.
Reverse Floyd, you say?
The reverse George Floyd. Nate sent that to me earlier, and let me pull up the article on that. But it is very interesting.
How do you reverse George Floyd? Like,
all right. So
did the guy on the bottom kill the guy on the top while getting kneeled on? Like, is that what happened?
No. Well,
or did he kill the fentanyl? I'm not sure which one.
If the Chauvin in the equation was the victim,
something similar to that.
Okay.
So in this case, you had the essentially the exact same facts. 3 cops go up to a guy. They're arresting him. Now he's high on methamphetamine, so they're arresting him. They take him down, and he starts screaming the magic words, "I can't breathe. I can't breathe. I can't breathe." There's a whole bunch of witnesses. I can't breathe. He can't breathe. He dies. Oh my God. So then, autopsy report. He's, crushed to death by the cops. Blah, 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 blah. But the problem with this one is that he had a lethal amount of methamphetamine in his system. So they go to court. Goes to trial. And the jury looks at the evidence and says he didn't die. The cops didn't kill him. He died because of the methamphetamines. So all the way, so they acquit him. And on top of that, the cops not only are acquitted, they get their jobs back. So now, because it's a civil service job, so they get their jobs back. So the city now, because they don't want these cops working, paid these cops each $500,000 a piece to resign. and the cops actually took the deal and resigned. So now it's like, well, hold on. In this case, you had very similar facts with the guy having a lethal amount of drugs in his system. They're found not guilty, but then in the Chauvin case, it's the exact same situation, but he's found guilty of doing life in prison. So,
may I ask?
These are inconsistent verdicts.
Let me ask the obvious, indiscreet question. What are the races of the victim and the police officer?
Cops are white, victim is black.
Same. Everything's identical, but you know what I think happened here, Nate? Is the timing of the trial, because in Tacoma, Seattle, we just had Jason Rantz on last week. He's a reporter up in Seattle area, and he reports all this. He's on Tucker all the time, talking about what goes on in that area. Well, they essentially made crime legal. They dumped, took millions off of budgets for the police forces. They went down. Crime just skyrocketed. People are dying in droves. I think in Seattle alone, their death toll went from like 100 a year to like 870 a year in overdoses because of what they were doing. I mean, so much was going on because of Chad and CHOP and legalization. There was essentially pro-crime legislation that the public lost their ever-loving minds, and it was all tied to George Floyd. Everything came out of George Floyd in that area to defund, and the people were so sick of it that I think that this jury is a reaction to that, and it's a relitigation of the George Floyd case.
I have a question about appeals. Does anybody know if there are currently appeals going on in the Chauvin case, and can you cite new case law retroactively in an appeal?
It depends on the case law you're trying to cite.
Sure, because I don't know what jurisdiction this is, and I don't know if this, if that can be applicable.
Well, you're not going to pull in like a district court jury verdict into your appeal for Chauvin because they're fact specific. Those are the finders of fact. Sure. This jury found that he died by overdose rather than by crushing or asphyxiation. That's not going to be appeal worthy. But in general, the answer to your question is it depends on the case law. If you get new case law that finds something unconstitutional that was used in the prior case, it's unconstitutional because it always was unconstitutional, and then you can potentially use that new case law in the appeal to get your verdict taken care of. But it's going to highly depend on what that case law is.
And Chauvin's already lost his appeal though too. So
yeah, Chauvin's.
Okay. And they're not filing. Are they filing anything new or no?
I don't even think you can follow anything new, right?
No.
He'd have to find a new avenue to like a new approach to file a new appeal. You have an unlimited or an almost unlimited right of appeal if you're in life in prison, but you always have to have like a new angle. You can't go after the same stuff and look for relitigating on the same issues.
To me, the most bothersome thing was
federal, wasn't it? The Chauvin case?
Well, he has a federal and a state case, which makes it worse because if he wins either one of the appeals, he's still got the other sentence to go off of.
Sure.
I'm going to ask you, Nick, because to me the most bothersome thing was the fact that the assault is considered the predicate felony to make it felony murder. And my question is, if the Minnesota Supreme Court were to overturn that and say that could not be deemed that, I assume that could relate back to Chauvin to say that charge must be dismissed. He still would be in prison for the rest of his life anyway. But.
Yeah, I think if I'm not mistaken, Chauvin was found guilty of both murder 2 and manslaughter.
Yeah, which also
on
made
no
sense.
There were 3 levels.
What about murder 3? Because I know there's murder 3 involved in the case as well.
Well, the highest charge was the felony murder.
The assault led to the murder, so it's a felony murder.
If he were to, they only sentenced him on the highest charge. So if he were to win an appeal and get that high charge overturned, then they would rehearing on the sentencing for the next highest charge, and they'd sentence him then based on the other factors. Which honestly, depending on when that happened, it could really work in his favor for a reduced sentence as like tempers simmered down. Assuming that they do, and like the explosive media nature of his case is gone, he could get a much better break on a second sentencing. But I mean, that dude's just fucked. Like that.
But you guys don't have you guys don't have the murder doctrine anyway. So it's like the assault leads to murder, and neither does Georgia. Georgia says the same thing. They don't have any murder doctrine, and the murder doctrine is assaults can lead to murder, because all, so everybody understands, all assaults, all murders are assaults inherently. To murder somebody, you have to have an assault. But in Minnesota and in Georgia, if you assault someone and they die, that assault can be a predicate for felony murder. So essentially, all murders can be murder once, felony murder for murder.
I want to know what intentional homicide can happen without an assault. Like, I want that scenario. Like, how do you do that? Because I want to try and find that case.
Poison assault.
I think it is.
Yeah.
Essentially poison someone, that would be an assault.
I'm not sure about yet.
Yeah.
I actually thought poison also. That was the first thing I went to, and I was like,
poisoning is an assault. Yeah.
Something negligent. I'm trying.
Well,
to
negligence would automatically not be murder.
Yeah.
Right.
And that's why most
maybe a
reckless
reckless homicide, like reckless.
But it wouldn't be intentional.
Starvation.
Intentional.
Okay, how about lying and saying that the gun is empty?
I see where Hunley's going with this one.
I'm thinking starvation.
That's a legit question. I mean, what about that?
What a great segue. What a great segue.
Hold on, before we segue, everybody, I have to go walk some dogs and squeeze some dogs before I go live at 2, so I'm going to check out.
Later, brother.
Good to see all of you. Why did we only have Nate's avatar today?
Because he doesn't,
It's bad hair.
It's
That's typical. He usually does.
Okay, well, Nate, I'll see you sooner than later. We might be in Texas. I don't know when, but I want to come.
All right.
Okay, I'm ducking out. Everybody have a good one.
Peace,
right.
Viva.
Yeah, let's go ahead and segue into that, because this trial I'm personally involved with a little bit, almost. Hannah Gutierrez Reed, the armorer in the Rust trial. That trial is coming up in February. I believe February 21st is the trial date at this point. And there's a few things going on. Right now, her attorneys want her ex's death to be excluded from the trial. And in a previous show, I know that I went back and forth a little bit with Nate, but I had said, what about, serial killers who have their kits? I can't say what kind of kit it is, but anyway, those bad kits who may have done other crimes, that'll come in as evidence because it shows, and Nate said propensity evidence. We were talking on the phone. At what point is it propensity evidence? Because apparently she gave the keys to her ex when he was very obviously intoxicated or something of that sort, and he perished. And I think that Nate was thinking that they could be trying to imply that she is so grossly irresponsible. She likes to walk into bars or liquor stores with a gun, things of that sort, that they're rolling this all together.
I don't like it.
Sure.
I don't know how it's relevant. I don't know how it's pertinent, but I want to know if the lawyers know anything about it.
Well, that'd
be the argument, right? Is how you make it relevant as a prosecutor, and the way to get around this, or to get this propensity evidence in would be to somehow link. What is it, Nate? It's like it's motive means.
Is it prior bad acts?
It's motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, and lack of accident. Those are the exceptions to the propensity rule. So you can use propensity evidence as long as the prosecutor is trying to use it for those purposes.
So if the DA would try to establish lack of accident, because this is just the way that she rolls. Perhaps.
Yeah, I mean, actually, you could say it's lack of accident because she's consistently reckless. Like, she's consistently entering into these or creating these situations and then entering into them without regard for human life. Human life ends. You could try that. Was she was she convicted in this in his death in some way, or
not that I know of? And this is the thing that I have issues with. Okay, the prosecutor is a special prosecutor. It's not the DA. The DA offloaded it and brought somebody in. This is the replacement for the original person, but it's Carrie Morrissey. I've had almost a slight encounter with her. Nate talked to her on my behalf. She's a very aggressive prosecutor.
Yeah,
extremely aggressive.
I remember when you got that call.
And she essentially has added on charges. It's like every time we look at the case, there's another charge that's being added to it. Some of them seem very reasonable. Like, one charge is that she was obstructing justice, I guess, or hampering the investigation by supposedly hiding cocaine from another person on the set. I don't know who, but another person, supposedly she helped dispose of it. This is a new charge that got piled on. Then she got this charge for carrying a gun into a dive bar for some reason, which why are these getting piled on? It's very interesting. There's also Carrie Morrissey apparently is going after Dave Halls, and Dave Halls is actually the only person who has been punished for the crime. He did a deal, and he's been fighting. I'm trying to find the story on that, but essentially she's been threatening him to force him to testify and whatever else. She's very, very aggressive.
But Alec Baldwin is being excluded as a witness, isn't he?
Alec Baldwin is being excluded as a witness, but they also did not dismiss the charges with prejudice, and she has threatened to charge him. She threatened him in October that he was going to be taken in front of a grand jury, or it would be introduced to a grand jury, but I don't know if it's happened or not happened, but he still has not been charged, and he's also not on the witness list. Nate explained to me earlier that he wouldn't be because he could just say, I plead the fifth, because they could charge him any second.
I'm trying to wrap my head around him not being on the witness list.
It's just not worth it. Like, if you bring him on the stand. Because, like you said, if he's just going to plead the fifth, like, if you bring him up there, you might just piss off the jury. Like, why are you bringing Alec Baldwin in? It's a spectacle. He's going to plead the fifth.
But I'll ask you and Joe, if you're Alec Baldwin's attorney and they put him on the witnesses and call him to the stand, what else do you tell him to do? Right? It's like he has no choice but to plead the fifth.
That's true.
Right?
Yeah. Now, if they dismiss the charges against him with prejudice, then they would have to. They would be.
Then he has
to
to testify. Correct? Yes, he has to testify truthfully because now he's not under any jeopardy. But until that happens, he's pleading the fifth.
Yeah, I mean, unless they give him immunity, there's no way he says a word. Well, I mean, there is a way Alec Baldwin says a word because he's a fucking idiot. But if his attorneys,
he loves to talk.
if his attorneys have any hooks into him, he'll just plead the fifth. And then what they're going to do is bring him in there. It'll be a big spectacle, and it'll get the jury kind of juiced up. But then it'll piss him off because he doesn't actually say anything. It's like, why did you do that?
I don't think he would take his attorney's advice necessarily. I kind of don't see him. I think that he's one of those clients who just goes against attorney advice. I just do not see. I mean, I could see him getting up on a stand. I could see him talking about the whole thing. He loves to talk about it. He's done interviews about it. Probably against attorney advice.
So here's where I'm going to refute you, Nick, on a couple of grounds. First of all, depending on how the trial is going, sometimes the jury is falling asleep, and bringing in Alec Baldwin is certainly going to wake the hell out of them. They're just going to all of a sudden be pert and alert, and so that sort of changes the vibe of the trial. The other element to it is that he, as Chandler's pointing out, he's a guy who rambles at the mouth more than I do, and that's saying something.
Wouldn't the defense want to call him? That's a good question, because it could help the defense if he says, I plead the fifth.
Yeah,
because that could imply, if they're trying to spread the blame out
on a road, like were you asking questions that don't seem so self-incriminating, and he suddenly just starts walking into saying things that are completely stupid for anyone to actually say. So he seems like such a ripe target to try and sort of bait into saying something stupid.
Well, he's very confident in his ignorance. Yeah.
Mm-hmm.
The number one thing,
Kruger to the
they would not have him plead the fifth in front of the jury. In a civil trial, maybe. In a criminal trial, no. This will happen at a preliminary hearing. The judge will say, "Hey, is he going to testify?" And then I'll argue he's not going to plead the fifth, because they wouldn't want the jury. Because it's like what happened to OJ and Mark Furman. You remember he pleaded the fifth all the time, but none of that was in front of the jury. All that was because it was like, okay, well, if he's pleading the fifth, it's not, it's going to taint the jury in a certain way. So generally in criminal trials, if you're pleading the fifth, you're not doing it in front of the jury.
But doesn't Hannah Gutierrez Reed have the right to call the person who was there because that is, I think that this, now we're getting into two different rights, because she is on trial literally, for her own life, and he was involved. He did pull the trigger. This is all known facts. Could her defense not call him?
But it's the same answer. Like, she can call him all day, but her right to cross-examine doesn't trump his Fifth Amendment right to not self-incriminate. So unless they were to give him some sort of deal where he's free from prosecution or dismiss the case with prejudice, he's still assumedly going to, in motion pleading, plead the Fifth and just say, hey, you know what? We're not, my client is not going to get up there and talk like an idiot. We know you want him to.
I feel like they'd have to hog tie him to keep him from doing that, honestly.
Okay, but I did find when I was talking about the Dave Halls thing, I got confused. Essentially, she had put his address on public records, and people were harassing him.
When you say she and he, who are you referring to?
Kerry Morrissey, the prosecutor, was putting his address down. He was like, look, people are calling me, they're harassing me. What are you doing? And the judge finally had to instruct her to say, hey, you need to redact this information. And she was like, well, he's not answering. So I put it out there. She's a very, very, very aggressive prosecutor, it seems.
Is that doxing legally, or? Assuming private information previously.
Doxing is not actually illegal if it's a public record, I believe. If I can go to the website of a city and find property information and say, here, that's doxing is a Twitter thing, and it's a social media thing, but that's a policy thing, not necessarily a legal thing. Correct me if I'm wrong.
I think there are laws in Canada against doxing. I'm not sure about the US though.
In the US, it really runs afoul of the First Amendment to make doxing generally illegal. The only way you get around any sort of First Amendment protections for something like doxing is to attach it to very clear and conspicuous threats of violence or harassment under the same standards that you would have like a harassment or what we would call like a credible or actual threat. So you would have to have it'd have to have the intent to be a threat. That intent would have to be delivered by not an idiom or some sort of like colloquialism. It would have to be intended to be delivered to the person in some way, even through a third party, but the intent would have to be clear on all that, and they'd have to prove it. It gets really, really difficult to show doxing to be a criminal activity in the United States, which in my opinion is how it should be, but not everybody agrees.
Well, Megan Fox has talked about that, about how it's so easy to find people's information if you just look through public records. There are lots of public records you can access through FOIA. And then additionally, so with this, it sounds like they can't really charge her with anything, but the judge can make that decision on and I'm trying to understand how the judge, told her to retract it or to stop, engaging if it is legal on what basis.
Well, the judges have pretty broad authority to control their courtroom and the flow of a case. So if they think something like this is disrupting the ability to bring a witness in because he's receiving threats and might go into hiding, then the judge could simply order the redaction. I mean, that's a minimally invasive intrusion on speech, and it's narrowly tailored to achieve the purpose.
They just wanted it sealed.
I thought it said redacted in the article there.
Okay, it did on there, but I see that it's sealed, or they were asking for it to be sealed, and that doesn't seem unreasonable.
Yeah,
it doesn't. But if the damage is already done and it has that impact, then the judge's order might just be a moot point.
You may have some ethical concerns too, because the prosecutors have the ethical issues that the judges could file with the state bar. But that, I think, it's not as illegal, but you may. It
feels like an abuse of power, but it's not. It's kind of a gray area.
It feels like bullying almost.
Sure.
Just saying.
Yeah.
And again.
Well, prosecutors.
My firsthand experience is that the prosecutor is very, very aggressive. I did not feel very comfortable with the conversation that was had about me. I will say that.
I can imagine that. Sure.
Nate, you can attest to it. Was it a comfortable chat?
Well, no, not on our end. But again, it's like, you gotta tell us what you want, or we don't give you. We treated her like a mushroom.
That's kind of their job.
Feed her crap and keep her in the dark, right? You tell me what you want. I don't give up anything.
Yep.
So, speaking of mushrooms and being kept in the dark, I'm going to go ahead and wrap it up with the audience.
Didn't know where that was going.
That's a segue that I have not heard before.
We are in Seattle now, apparently.
We definitely are. Where can everybody find you? What's going on, Nate?
Just Nate the Lawyer, any Google thing. And I do videos on demand. I'm doing one with Chandler. Hopefully, if we can get the timing right.
Yes.
Hopefully, we're going to be shooting that maybe tomorrow. It's on. Obviously, I'm doing a lot of these stories on these crazy people. The Dalton mayor, Joe. I thought you were going to start taking care of some of that.
Sorry, I'll do some looking for you.
Yeah, but she's broke it out. It's like going crazy, and just a lot of crazy stuff. Like obviously, the most recent one was the blank by deception, where the twin pretended to be his twin brother and had sex with his twin brother's girlfriend. And the prosecutors were like, well, how can we charge him? Because if you fool someone into sex, that's actually illegal. And it's funny because there's like a crazy case where this woman, so this is a case from 1985. I'm going to be quick about this. 1985, a woman gets a phone call from a doctor's office. Hey, you have this crazy disease. There's 2 ways that you can get cured. Number 1, go into the hospital for 6 weeks, highly expensive and horrible surgeries. Or number 2, I can set you up with this guy in a hotel. He's anonymous because of HIPAA, and you can have sex with him because he's been injected with the serum, and we could do that for half the price. And she does that for half the price.
Heck yeah.
Then eventually calls the doctor's office, is like, hey, I'm cured. And the doctor's office says, cured of what? Because your blood results came back great. So he's arrested for blank. But he was found, but the courts threw it out because they said you can fool someone into intercourse. And if you do that, it's they have consented to the act. So it's a crazy case, but yeah, that case is on the channel. And so those are things that we've been looking at.
So it sounds like a cop again.
Crazy. Yes.
It's a case where the other person's stupidity is your defense, and it works really well.
Yeah. Well, this woman was with it. They proved this woman was actually fooled, but then obviously the jury was, and everybody else was like, how could you be fooled by that? But she was fooled. She was fooled.
Well, fool her once, shame on her, I guess. Rule the court.
That's pro gamer strategies right
That's
there.
No,
quite the case. Wow, I'm looking forward to hearing about that one. Nate.
Sounds like
That's
he got
really
paid
interesting.
also.
So
yeah.
now every
How'd you
hustler is
convince
going
her
to
to
have
pay you
this
for that?
precedent.
She paid. She not only did she go to the hotel, she paid him and then thanked him after the act. Thank you for saving my life.
Thank you for your service.
Oh my God!
It's called Borough. The court. It's called Borough versus Superior Court of California. Yes, she paid him and thanked him.
Oh God!
That's
Her dance card is going to be quite full, I'm sure. Chandler, what do you have coming up?
So I am doing a show right after this at 3 p.m. Eastern Standard Time with Danny on Direct. We are going to be talking about Ruby Franke, Lori Mallow, under the heading of malicious mothers, and how mothers have a higher propensity for harming children and engaging in the unaliving of their children. I'm also probably going to be on Megan Fox's channel next week. We're talking about the Clayton Eckerd case with The Bachelor. This woman who engaged in oral sex with a man on twice in one night, and then claimed to be pregnant with his twins and
happens all the time.
him. Yeah, it's very common.
Especially when you do it twice. That's why you get twins.
Well, for this one, it happened to her apparently 3 times with 3 different boyfriends, but it was very traumatic for her. So yeah, so I'm going to be talking about that on Megan Fox's channel next week. I'm also going to be on Legal Vice's lovely evening stream called Lady Bits. So check me out there.
All right. I had some tips that came in. I just happened to see on local, so let me run through them real quickly. All you need to see to learn about the corrupt FBI is Viva's interview with A. Luna. Entry required is in Sweden. I have a Swedish audience member and said that the internet is fine in Sweden outside of Gothenburg, if I'm saying that right. And then entry required also said, question, pleading the fifth, let's say I am a vegan influencer and a famous televangelist who was called to the stand to testify regarding a murder I may have seen at a pig roast at a notorious strip club in the company of my mistress. Can I be compelled to testify? My testimony would be very damaging to me. I'm going to say yes.
That's a loaded question.
Probably. Help me out with that, because just because he's screwing around doesn't mean that he is prevented from testifying, right?
I mean, he's not prevented from testifying unless you can plead the fifth if you're, in danger of incriminating yourself, right? Like you could do that. The other thing is he could just not remember a damn thing. It's amazing how often people forget. But that's part of the whole witness process, right? Like you have to select witnesses who are going to be compliant with your requests. If you try and force a witness to the stand and compel them to testify, you're going to get bad testimony. I mean, I don't remember shit ever. When were you born? I don't know. Like they're just not going to comply, and that's usually the answer to most of this stuff. So if someone was, out fucking around with their mistress and they don't want to testify because it'll be personally damaging to them, you're probably not going to get them on the stand.
Vegan at a pig roast too.
Oh, I guess that's
a little problematic.
They're vegans. They should be compelled to testify
or his food, but anyway. Anyway, what do you have coming up, Nick?
Oh, I don't know. Shows on occasion. I'll do one tonight at 11 p.m. Central, probably. But my life schedule has been really interfering with my show schedule lately. So that the plan is 11 p.m. Central Time, normal show tonight, and then normal shows next week. But lately, I've been getting curveballs all the freaking time. So I'm looking to actually change up my schedule a bit and have less night shows and maybe add in some daytime shows coming up soon to balance that out. But I have to figure out where that fits in my schedule. But you guys can always check me out on YouTube. But the main show and the full show is on Rumble. Ricada Law. Come listen to all of the slurs.
All right,
now haven't heard of it.
The tradition of this channel is for Joe to have the last word. He always pitches something, and then he likes to, have thoughts. Some would say wisdom. I would say thoughts, and he likes to share them with us, and we close out with that. So, Joe, what do you have going on?
I know you're making a joke about that, but this time I really have a great thought. But I mean, okay, well, I'm Good Logic. You can find me at goodlogic.locals.com. That's goodlogic.locals.com. Wait, my mic cut out. It's goodlogic.locals.com. On Monday, I am actually going to become an official member of the press, which means I am licensed to lie to you. I am going to be going to New York City and picking up my press badge, which now enables me to walk into New York State, into a court in New York State, and actually film and actually like use my phone, which is asinine that I have to be, that my status as an officer of the court is a lesser than compared to a member of the press, which is why I got this press badge. And then at 10 o'clock, I plan on taking that press badge, going down to courthouse where hopefully they say Donald J. Trump is going to be testifying in defense of his defamation claims that were raised against him by a certain lunatic by the name of E. Jean Carroll. And I plan on providing reports and updates of that. So you should probably follow me.
That's right. You can call her.
You
can call her a lunatic, but he can't apparently, right?
I don't think lunatic. I think lunatic is not derogatory for her. I think
that's a soft term. That's a generous term.
that's generous. I mean, and it's clearly a statement of opinion also. So that sort of helps me anyway. But the really interesting thought that I wanted to drop on you is that if we think about everything that's going on in the world right now, and you really get down and boil down as to like how the world is suddenly collapsing in on itself and coming into 2024, which is an election year, the most important thing for you to remember is that